Hello there. I'm Sue Wells, the Executive Director of the Arbitrators and Mediators Institute of New Zealand. Thank you for joining us in this first edition of our series on doing business better. We're joined today by the team from Immediation and Codr, who are going to show us a demonstration of online dispute resolution technology that I know you'll find very interesting. And to start that off, I'd like to begin by introducing to you Mike Heron QC. Hello, Mike.
Good afternoon. Hi, all.
It's lovely to have you with us, Mike. And today's topic is about online mediation. Now, you are the founder of Codr, C-O-D-R, Codr.
That's right.
What's that? Tell me about that.
Well, it's complete online dispute resolution. It's my little idea, which launched a few years back, and we've done a few online mediations and managed to come across in the world of ODR these people below on the screen, Laura, Keily and Nick Northcott, who have this amazing product and service in mediation. So I guess that's what we'll move on to discuss. But yeah,
so just tell me a little bit, Mike, about online dispute resolution. Mediation online has been a happening thing in New Zealand for a while now.
Yeah, I mean, it's embryonic. It's really a globally recognised specialty. There's even an international kind of council, Codr. There's practice groups, a global conference. We hosted it in Auckland probably a year and a half ago now. So, and there's a recognised group of experts around the world who talk a lot about it, write a lot about it. So it's quite well developed in many countries. Not so much in New Zealand.
Is there a reason you think that New Zealand might be lagging a wee bit behind?
Oh, there are probably many reasons, but inertia is one thing, maybe a bit of distrust, maybe the technology wasn't quite there, and that's what you'll see soon is some really slick technology now through a mediation that, you know, makes it a whole lot more manageable and understandable, really.
Excellent. So let's move on now to mediation, Mike. And if you'd like to perhaps tell us about how you got together, where your project is up to, and introduce us to Laura and Nick.
Yeah, well, thanks. It's my privilege and pleasure. Laura Keily, as you can see, is if you look at her LinkedIn or Mediation's website, you'll see she's a commercial barrister based in Melbourne, Victoria, practices at the commercial bar there, but has 3 degrees, including a science degree, honours and masters, Laura, but really, and dispute ADR qualifications, but the founder and CEO of Immediation is really the relevant topic, which is a startup, to be fair, Laura, but it's a whole lot more than that. It has this superb software, and they have some great brains, one of which is on the screen as well, Nick Northcott, who's an executive director. And we met, I met with the Mediation at an ODR conference in Melbourne, must have been a year or more
18 months ago.
18 months ago. And yeah, it goes from there. We've been in dialogue since, and it's hard to describe exactly our formal legal relationship, but close collaboration. And one thing is, I believe in ODR, and I really believe in what Immediation is offering. So that's hopefully a summary.
So Laura, would you like to tell us a little bit more about It's Immediation.
Mediation, yes.
Yeah.
And thank you, Sue. And just to give a bit of background of the name, obviously it's the words immediate and mediation combined in one. So hi everybody, my name is Laura. It's great to be with you today. As Mike mentioned, I'm a barrister at the Victorian Bar, and I have been for 6 years now, practicing mainly in the superior courts. I also have recently completed the Chartered Institute of Arbitration qualification, so I'm now an arbitrator. And prior to that, in my former life, which I think is probably what led to the creation of this business, I was a mergers and acquisitions lawyer for 15 years at Slaughter and May and Blake Dawson Waldron and Cause Chambers Westgarth, and an in-house counsel. So I think with that corporate background in mind, when I got to the bar, I was a little bit, I guess, concerned about the number of people below the echelon of blue chip that I was used to dealing with, who were having massive struggles dealing with the court system and tribunal system and simply unable to resolve their disputes. And so the premise behind the original idea was that we would provide a mechanism, which was the platform, a web-based platform for people to communicate their disputes with one another, regardless of whether they were legally represented or not. And then to come into contact very early on in the piece, ideally within a month, with a highly qualified member of the profession to help them resolve it, either by mediation or arbitration, or indeed a different form of ADR, such as expert determination. And so what we set out to do originally when I started this in 2017 was to build the technology to facilitate that. And then the second part was to have a world-leading panel of lawyers who could come in onto the platform and resolve the disputes with people. And so last year in October, we commercially released both the product, the technology rather, and a national panel of former justices, including former Chief Justices of the Supreme Courts of Victoria and WA, former federal court judges, and a whole series of mediators and arbitrators at all stages of their career, and indeed partners of law firms whom we felt had a particular specialty to offer. For example, in giving an expert determination in fields of their specialty where parties were highly experienced and simply required an outcome. So that was the background of what we did. And it's fair to say that that process, as Mike has said, has been great, but there has been a degree of inertia in the profession as to the take-up of service-based ODR, although it was slowly moving. And in fact, prior to this, we had a long list of enterprise clients with whom we were and are continuing to deal, who were looking at more institutional level take-up. What's happened with COVID is that the, very unfortunately, on one hand, but fortunately on the other, the conversion, what we call the conversion of the legal profession to new ways of working, has happened overnight. It's because there is no alternative. So it's a real opportunity for platforms like this to come into their own and be utilised, albeit much more rapidly than we expected. So what we have done and pushed the accelerator on is a second version of our platform, which I'm going to show you today. It hasn't been released yet for subscription, but it will be within days. So it's our platform technology that we built for our panel members, translated into an easy to use subscription-based format. And we did that so that mediators and arbitrators and lawyers can run their own practices using our market-leading tools without having to engage our practitioners. So what I'm going to do now, perhaps I'll just pause and see if there's any, well, I don't know if I'm allowed to pause and see if there's any preliminary questions before I go in and show you the platform itself.
Absolutely. So if, to those of you, the 55 people we have attending live, welcome to all of you. I think you probably all know how to raise your hands in this forum. So there's a little chat button at the bottom of your screen. If you pop on that, you can raise your hand up through that. Drop me a little message and I'll keep my eyes out to see if anyone has their hand up and wishes to ask a question at any point. So not seeing it go up, but
all right, I'll carry on then. So I'm going to share my screen now. I'm hoping that has worked.
It has.
I'm just going to go to this screen now. Because I already have an account, it's a bit difficult for me to show you what you will see when you go to the internet. But in essence, what we have here is... Is it
possible for you to make that larger at all, please? Thank you. Keep it coming. That's really good. Thank you so much.
Okay, so if you imagine now that I have purchased a subscription to Immediation, now we're calling this product Dealmaker, and the tagline for Dealmaker is from disputes to deals. The reason that we have called it from disputes to deals and Dealmaker is because Nick and I have a particular theory, which is that if we can start to get people to look at a dispute like any other commercial negotiation, albeit one in a very heated and sometimes aggressive environment, then we may be able to shift their mindset more to interest-based resolution rather than focusing on the fight. And so we've called it Dealmaker for that reason, because we want to empower mediators and lawyers to feel like they are able to resolve things. The other reason we've called it that is because we can see that this technology may be useful for things other than dispute resolution, such as transactions, negotiations, client interviews, witness conferences, preliminary conferences, etc. So we're trying to broaden the concept away from simply online dispute resolution. Now, this is my list of matters, and when you go onto our new website that says Dealmaker, you'll be taken to a basic subscription page. And just to put that cost in context, the cost will be less than $100 per month. It's likely to be around the $70 per month Australian mark for unlimited use. So assuming that I've subscribed by entering my credit card and that's all fine, I'm now a user of Dealmaker and I can create a matter. So the first thing that you're greeted with is a screen that says create matter. Tell us about your meeting. Now this is both for your own purposes in knowing how to describe the meeting for the create matter list, and also to inform the people whom you're going to invite about that matter. So you can set a custom matter number, which is a bit like my reference if you ever see solicitors' correspondence, and you can call it whatever you like. If you're using it on behalf of an organisation, it will recognise that you are a person on behalf of an organisation. So let's just call me that. It will also ask you, is this the subject of a legal proceeding? In which case you can enter the court reference number just for ease of reference later. Now it asks you what type of online meeting will the product be used for? And you can see a drop-down list. I've actually expanded this list overnight with our engineers to include more functions here, but there is really no limit to the number of things you can use it for. Let's just say we're using it for mediation. It then asks you to select your role. Now, again, I've expanded the list overnight, so there's quite a long list of potential roles to choose from party names to lawyer names, to neutral parties, to experts, to witnesses in any guise. So let's just say I'm the first claimant, and I'm the first claimant actually, let's call me the neutral. And as of tomorrow, you'll be able to name yourself the neutral mediator or the neutral arbitrator and so on. The next step is step 2, tell us who to contact. So this is really like you're inviting people to a meeting. It just is a very specialized meeting. And it's asking me to enter people's email addresses and then their role. So they will be invited, for example, as the first claimant and so on, and you can add as many people as you like and nominate their role. It then asks you who will be in charge of the meeting controls, and this is really because subscribers are the ones who are able to run the meeting, which is for obvious reasons. You can invite anyone to participate free of charge, but if you want an account where you can create meetings, invite people, and then run the meeting, you need to be a subscriber. The next step is that you can upload documents by drag and drop that you want to be viewable to the parties in that mediation. You might like to say why these are relevant. You might like to say this is my preliminary directions. as a mediator. Or if you were a party, you might like to say it's my position paper, or you might like to say it's my expert report, just to give people an explanation as to what these documents are. If you still need something from the other side, you might say here, I still need the second defendant's expert report, please, just as a reminder that they need to upload materials. Click next. Now there's a scheduling tool. There's a couple of options here. One is that you know the date and time when you want the meeting to occur, which is pretty straightforward, and I'll come to that in a moment. The next is that you want everybody else to advise you of their blackout times so that you can choose from the balance. And the third is that you just want the room to be open. So for example, you can imagine if you were negotiating a very large transaction or a dispute that was ongoing, you might just want to leave that room open and just manage it, people coming in and out on an ongoing basis, or when you advise them by text. So either of those or any of those are open to you. Let's just say I know the date and time and it's selected right now. So that's all you need to do. It's now asked you to accept the platform terms and conditions. You can see all of the people you've invited and their role. You can see the files that you've uploaded and the date. And all you do is hit submit. Now what will happen is the parties will receive an email invitation. It will say that they've been invited, and it will reference all of the information that you have put in the invitation. So it will say that it's a matter of plaintiff versus defendant. It will say that they've been invited to a mediation by you as a neutral. It will give them the date and time and say that they have been invited as the first claimant. And it will also ask them to upload any information to the platform. So what then happens is the person who's the recipient of the invitation clicks on it. They'll be taken into the platform, asked to enter their password, and they will go into an account that looks exactly like this. What we might do now, Nick.
Apologies, I have a question from
yes.
Terry Sissons. Is it all right to ask a question now?
Absolutely.
Terry, all yours. I think that should have unmuted you. Away you go, Terry. Nope, I haven't unmuted Terry. I think I've managed to bump him off completely. I'm sorry about that.
I think he's still there. No, there he is.
Yeah.
Are you there, Terry?
My question was, from a subscription point of view, if I subscribe as a neutral, do the other parties to, they say, a mediation need to subscribe as well, or is it just one subscription?
Sorry, I'll unmute myself. It's one subscription, Terry, so that you can invite as many people as you like, as often as you like. What they can do is they can come in and they can participate, but what they can't do is they can't go and create their own matter, and they can't run the platform. So only you as the neutral can run the platform. And I'll show you what I mean actually right now, if you like, by running the platform.
Okay, thank you.
Thank you. Now there's one I prepared earlier sitting here in the background, so I might just close that screen down. Right, so you should now be able to see other members of our team. So Jennifer and Nethmi, I'm not sure they can even hear me. So everybody, oh, I've got bounce back. Can everybody mute, please? Thank you, Nick. So hopefully everybody can see now that we're in the platform. So all I did before was go on to that matter number and hit show, and then it takes me to an online meeting, and this is the meeting. Now you can see that some of the audio, the video quality is a little bit pixelated. That's because the platform will adjust to people's video quality through their internet and try and maintain them in the meeting for as long as possible by degrading the quality of their video. Unfortunately, it does require, as all platforms do, decent quality internet. Now, Nick, are you seeing that pixelation at the moment with Jennifer and Nethmi?
I am, and you're also circulating a platform through a platform as well, which is, there's a bit of a
absolutely
effect that's happening here as well.
Okay, so if that degrades further because of my bandwidth, I'll switch to Nick. Indeed, Nick, would you like to take over now? And given that you're deeply engaged in building this product, do you want to take over the run through?
Happy to, Laura. Yeah, if you are.
I'll stop sharing.
Well, good afternoon, everybody. Firstly, pleasure to be here with you. All right. So I'm now sharing with you the Immediation Dealmaker platform, as Laura said. And what you can see up the top of the screen here is it describes the room that we're in. So we're in the general room, and we have 5 participants in this session. So we have Laura, whose role is described clearly as the first claimant, and we also have Nethmi, who's the first respondent. You'll see the little tag up the top, and Jennifer as well, who's also the first claimant guest representative. And we have Gideon, who's one of our developers, who has his video turned off, which is why the screen should be black for you. You'll also notice on the left we have this participants tab, and on the right we have this messages tab. So we know that you have limited real estate space when you're dealing with video platforms, so we wanted to be able to fill your screen with the people that you're speaking to. And for those who don't know me, I'm a qualified mediator. And for me as a mediator, what's really important is being able to read the room, being able to see people's faces, being able to understand what's happening. And so, you know, that real estate's really valuable. On the right, we'll just run through some of the features here. We have a messages tab, and that allows us to, up the top, the right, you'll see 3 tabs there. There's chat, files, and agreements. So the chat function allows me to either in a group session by particular rooms, which I'll come back to in a moment, or by individual participants, send messages. So I want to send Laura a message to say, you know, hi Laura, and she will have received that, and she'll be able to respond in private. I'll also be able to, she might respond back in a moment as well. I'll also be able to respond back to the general room and say, you know, rather than good morning, good afternoon, everyone.
Nick, I might just interrupt you there. I'm not sure if everybody can see your screen, because at the moment it appears frozen to me.
Okay, how is that?
It's moving again now, that's better.
Okay, great.
Thank you.
Apologies for that, folks. So we have, as I said, hopefully you heard and saw all of that. We have 2 tabs. So our participants tab on the left and our messages tab on the right. So you can chat by either individual or group chat. You can also share files and documents. So earlier today, Gideon uploaded a settlement agreement, our template settlement agreement. So you can either view that settlement agreement as such, and you can scroll through and have a look at that, or click off it, or you can download it by just clicking on that little tab there. We also have an agreements function, which I'll come back to in just a moment, where you can create and edit agreements. But for now, I'm going to just show some other cool features which we know are really important. You also have down the bottom here these kind of controls to be able to leave the room, to be able to mute yourself, to be able to turn your video on and off. In addition, you can also share your screen. So you can do that very similar to what we have now, either your entire screen, an application window, or a tab. So in the course of a normal mediation or hearing or a matter, you would want the flexibility, certainly I would as a mediator, to move people like you would in real life between rooms and to control proceedings, as Laura has talked about. So for the purposes of this, we have on the left tab here, this participants tab. And at the moment, you can see we have effectively like you would in real life, imagine virtual rooms. So we have a council only room, we have a general room, and I'm going to create, another room. I'm going to create a claimants room. So I've created that claimants room. And what I'm going to do is I'm going to transfer Laura and her counsel. Maybe it should be the other way around, actually, Jennifer. I'm not quite sure that works. But let's, for the arguments of this sake, let's say that you're advising Laura, just for a bit of fun. And let's transfer you into the room. So you're going to see Laura and her counsel disappear in just a moment. Okay, transfer Laura into the claimant room. And off she goes. And I'm going to transfer Jennifer into the claimant room also. So now as the mediator, I can sit here and I can have my conversation with one party in the general room. But actually I might say, do you know what? I want to put the respondents in their own room as well. And I'm going to take a quick little break. So I'm going to create a respondent room, and Nethmi, I'm going to send you off there to, you don't have any counsel, so you're going to be on your own, Nethmi. So I'm going to transfer you off there, and I'll be left with Gideon in this room on my own.
Nick, if you like, I can share my screen and actually show what it looks like in the private room.
Sure, okay, I'll stop.
Oh, so you can see now, unfortunately, all of that moving around has caused Jennifer to go pixelated. But you can see here it says claimant room. I'm in the claimant room with Jennifer, whose face has gone pixelated. And I'm going to go back out now and go back to Nick.
Don't forget, folks, while this is happening, you're very welcome to ask any questions that you might have. You can do that either by using the chat function at the bottom. There's a little Q&A, and you can just raise your hand and we'll come to you as well. Back to you, Nick.
Oh, excuse me, I was muted. Thank you very much. I think I'm unmuted now. Yes, I'm going to bring everybody back into our main general room. We can start proceedings again. What I probably would have done is, as the mediator, I probably would have had conversations, either jumped into the room and spoken to people and let them know, like I would in real life, that we're coming back into the room. Or actually, I might have done the virtual knock on the door. I might have gone to the chat and gone to the claimant room and written, "Hi folks, are you ready to come back?" And then they could message me back. So you've got a couple of options there, because we recognize some people work in different ways. So you might want to use the chat function, the virtual knock on the door, or you might prefer to actually, as the mediator or the arbitrator or the person running the hearing or the matter, jump into the room and say, I'm going to bring you back in 20 seconds or 15 seconds. And that way they've got that heads up. So it gives you control, as Laura said, around the process. You can share your screen, you can move people in and out of various rooms, you can create private rooms as you wish, you can chat, you can share files and documents, and one of the cool functions is the agreement function. I might pause before we talk about that and allow Laura to make some commentary around this, because we've done some interesting work around what this can be and how this can really add value to this process.
Sure, absolutely. I must be unmuted somewhere. How's that? Can you hear me?
Yes, that's fine, Laura. Carry on.
Sorry, I'm just in two platforms, so I have to make sure that I'm muted in one and not in the other. Nick, if you can just drive while I talk. So in the files section, if you look at Nick's screen, you can see that the files are grouped by reference to whomever it was that uploaded them. That's for obvious reasons, and files can be uploaded and downloaded either in advance or during the course of the mediation or matter itself. So Nick is now going to upload a file. recovery rocket, and you can see in real time that's uploaded. And then as a different member of the team or somebody else, the neutral, that can either be viewed by that little eye icon or it can be downloaded. Now, what Nick has just shown you by reference to the next part of the functionality is a template, and we were going to call this product Immediation Lite, so that hasn't been updated yet. We've got a template settlement agreement that sits in the back of the platform, and what we envisage is that over time, in fact, the list of precedents will continue to grow, so that over time you may have more than just a settlement agreement. You may have other documents that can be very easily utilised. It's a very basic agreement in the sense that it has certain boilerplate that is generic. If you scroll up a bit, Nick, that will be useful to me. It just has, you know, your standard non-disparagement, confidentiality, mutual releases, settlement terms, default. I think I put in a few things like bar to proceedings, just to make sure it was very robust. But in essence, it's a vanilla mutual agreement that anybody could feel confident, whilst we don't give legal advice, but anyone can feel confident that this agreement is going to stand up. And it's obviously drafted in Australian terms at the moment, so just bear that in mind. And
are these all things that would go hand in hand with the subscription, or is that if you're in a different sort of platform?
No, you can, anybody can use our standard settlement agreements that are in the back end of the platform. Now, what will happen is if Nick goes to the agreements tab, sorry, actually, if you go first to the schedule, Nick. Now, I must admit, there is one thing here I do wish to change, which is these schedules here, but for this purpose, these schedules here relate to what I'm about to show you. So they're schedules to the agreement, which connect to schedules on the platform. So if you just have a look at that and then go to the agreements tab, Nick. So what we've crafted here is effectively the ability for parties to, and the thing that's missing here that I need to fix is that the settlement sum needs to be one of these fields as it is on our main platform. What it allows is for the guts of an agreement to be drafted on the screen in real time by filling in the fields in the back of the schedule rather than drafting the front end of an agreement. So if you imagine that when it's corrected, it'll say settlement sum and payer as well in these fields. And that what the functionality of the platform actually draws those fields into the settlement agreement itself. And then the parties can co-draft in real time this drafting. In fact, Nick, what we might do, I don't know if it's too difficult to flip out of this and into the main platform to show how the functionality works when it's actually fully completed and released.
Yeah, sure.
I just feel like this is in production right now and it's not optimal.
No problem. I mean, we've got a couple of questions from the virtual audience. And I'm wondering whether we might just quickly answer those as we're going on.
Okay.
And we can maybe jump to that as well. So the first question is from Anita Chan around, can the two people or the number of people in the claimant's room talk to each other even when the neutral is not there? And the answer to that is absolutely yes. So they're private rooms for those parties. Imagine like you would in real life, move from room to room. So if you were to take the claimant's parties outside of a physical mediation room where they're together into a private room, they can discuss without having anyone there. Or even if, for example, you might have a scenario where actually, you know, the two barristers, the two lawyers wanted to come in and have a conversation, you could just quickly set up, you know, lawyer's room, right? Create the room, transfer the two relevant parties. They can have a private conversation without their clients in the room. So absolutely, yes, is the answer to that, Anita. We've got a few more questions coming in as well, and I'll just acknowledge them. I'll acknowledge them quickly. So the next one's from Paul Muir around what might the fit of the program be to family dispute resolution processes. And a question that's related to what I just mentioned before around, and I'll come back to the family dispute one, I'll kick that to you, Laura, in a moment. Is it just the mediator who can transfer people, and can parties have offline chats without having to be in a party-specific private room? So to the second part, absolutely. We can put any party into any private room. So for example, I might transfer our developer Gideon into council room by Gideon, and I might transfer you know, somebody else into a private room. I can put any combination into a private room.
Nick, I think the way I interpreted that question from Emma, and I'm not sure if I've interpreted it differently, was can parties choose to have offline chats without the neutral having put them into a private room together? Can they speak off behind the bike sheds without your consent, Nick?
The intent is that wouldn't happen, and the reason being is we don't necessarily see it as being egalitarian, although there is a discussion about whether that is something that people would want, and if it is, you know, probably something that can be achieved. But at this point, the idea is that it's the neutral that has the control over that process.
I'm just going to let Emma, who actually raised that question. Hello, Emma. Would you like to speak to that?
Thank you. Thanks both. Sorry, that was so. Nick, thank you. That happily answered my second question. My first question was very poorly drafted in retrospect. What I was meaning is that chat column, that chat panel you've got running on the right-hand side of your screen, can that channel be running? So yeah, so council only, for example, while we're in the general room.
Yeah, absolutely. Yep, absolutely. So I could be.
Thank you.
I could be in here, you know, going to the lawyer's room. Hi, you know, I think you need to come back, right? We need you. So absolutely, that can happen.
Nick, there's an excellent question that's just come in from Margaret Casey, who asks, what about confidentiality of the documents uploaded? Can the program provider access these at any stage, or are they confidential to the subscriber?
Yeah, that's a great question. Laura, I'm happy to take that unless you would like to respond to that.
I think the reality is that the documents probably can be seen by us, but they can also be deleted either upon request or purged from the platform. So what we're intending to do is purge things from the platform. It's very difficult for, well, Nick, you may have a way of that you've thought of that we can actually shield ourselves from seeing what's on our platform. We can talk to the engineers about that. I haven't actually had that question arise before.
We can create a, at the moment we haven't, but we can create, you know, effectively a Chinese wall between everybody in the documentation. If there's a broader question around security and encryption, maybe the short answer to that is we're on local Amazon servers. So for Australia, they're hosted in Sydney. Hopefully that's acceptable for our colleagues across the ditch. If not, then there's a conversation about that. And we also have encryption at the whole of you know, application level. But then we're in a special part of Amazon called S3, where we have special security and encryption at the document level. So if you know, an unnamed hacker from an unnamed state were to, you know, get into our platform, they would have to, one, get through our encryption, and then two, unencrypt every single document, and then put all the pieces of the haystack together. So it's about as secure as you can possibly get.
Are these mediations, or are these recorded as they're going?
No, they're not. Effectively, they're not, no, Sue. I mean, I think the reality is that probably the provider of Twilio, which is the video conference platform that we back onto, probably does record things, but we can't access that at the moment. And we don't intend to, and we can also ask them to delete it. There's certain things that happen at a higher level that are impossible to control, but the reality is that's also happening on Zoom and GoToMeeting and everything else, is my understanding of how these things work. It's just that we don't know.
We have two other questions as well, just to quickly answer them, which I did on the chat, but I'll just acknowledge there was a question around a virtual whiteboard, and that's what I keep bringing that up. It's coming very soon, so thank you for that question. It's not a feature that you see right here, but it will be with us very soon. And also, Paul, you had a question about family. I'm not sure, Laura, whether you wanted to talk about what we're doing in the family space as well.
I can talk about it at a general level, but I probably can't talk about the specifics. If you don't mind, we are progressing with a family law panel and integration with very advanced technology that enables the collection and manipulation of information in family disputes and the production of consent orders and relevant documents for the Family Court of Australia. We expect that we'll be able to integrate that with the Family Courts of New Zealand fairly rapidly. For the time being, what we suggest is that you run a family mediation like any other, and that you control the documents that you need using the share screen functionality, if that can be a workaround for the time being. Hopefully that answers the question. Mike, did you want to add anything there about your special whiz-bang automated documents for family?
Well, yeah, I mean, many people will know of Automio. We use them, collaborate with them, and do separation agreements and relationship property agreements, and then provide the advice and certification that all the family or relationship property practitioners will understand. It's early days. I think we've probably done about 75 of those, and they're going pretty well. Sadly, current events might make them even more popular. We'll see.
Okay, thanks, Mike. I'm not sure if there are any other questions for the moment, Nick, but what I've done behind the scenes is get the ladies to jump out of the Dealmaker platform and into our normal platform, so I can show folks how the settlement agreement functionality will work once it's been finessed.
Just one more before we start that. Cole Smith is asking, is there a way that the proceedings can be recorded for an arbitration so that one can get a transcript?
Yes, there is, and we're implementing that as well.
Excellent.
So the way is that we are able to extract upon request from Twilio, which is the video conference provider, a recording. And we obviously don't do that because we don't want to do it for mediation, but we have on our main platform already enabled that for hearings in a tribunal and court starting tomorrow that are using our main platform. And so they'll be able to get an MP3 file that we can provide that can be converted to transcript.
And is that functionality, again, is that through the subscription basis, or does that mean that you need to have a different subscription than just the month by month?
No, that will be the month by month.
Okay.
And ultimately, what would be great is we'll automate the transcription for you too, ultimately, just to make life even easier, right? It's one less thing to do.
Excellent.
Great.
So if everybody's all silent for now, I might just pop into our main platform and briefly show you a couple of things so that, which we are finessing the settlement agreement of Dealmaker in accordance with this. So Jennifer and Nethmi, I'm about to broadcast you again through the webinar. Okay, so now what you're looking at is our main platform. You can see that it's the UX, that what I mean by that is the way that it appears to you is slightly different, but the functionality is in effect the same. Now, the Rooms tab again here looks slightly different, but the thing I wanted to show you is the functionality here, which is what will be reflected in the deal maker within the next 48 hours. So as a mediator, I can turn on, if you remember, the settlement agreement with the fields, and the fields are reflected here on the screen. So I'm going to change the scribe to myself, and I can pass the pen around to anybody in that mediation. So for example, if Jennifer was a particularly perfectionist lawyer and she wanted to do some drafting herself, we could add it to her, pass it to her. So for the time being, I'm going to be the scribe. And if you see here, I've entered the settlement sum of $1 million. I've entered that the payer is going to be the respondent, and the claimant is going to be the recipient. The payment terms are going to be 60 days and so on. So the key commercial terms of a settlement in a commercial setting. I can also change that scribe around. So I may pass the pen now to Nethmi. And apologies, Nethmi, you've never probably done this before, having just joined us, but I'm going to set you as the scribe, and you'll see that the fields have changed. So if you just change the settlement sum, Nethmi, to something else, $50,000, for example, you should be able to see in real time. Can you see the settlement sum? If you just change that from $1 million to something else. Okay, so she's changed it now to 50,000. So she's had a dummy spit. She's decided that she's revoking her offer for $1 million and she's changing it to 50, and she wants to draft that. So that's fine. I decide as the mediator that I'm going to take control back, and I'm going to set myself as the drafts person, and I'm going to draft the final clause of the contract, which has been cut and pasted from something the respondent sent me. And that's really just why we call them a scribe, not a drafter. And you can see, and so on and so forth, people can draft collaboratively. When the mediator is finished or satisfied that the parties have agreed the commercial terms of this agreement, and I might just add here that the additional settlement terms is intended to be for free drafting. So somebody might, who was very enthusiastic, actually say clauses 2 to 15 are deleted and replaced with the following, and cut and paste their own agreement if they were that interested in that, in doing that. The mediator then hits finish terms and request signatures. And what it now does is create a document for signing, which I will show you, by e-signature. Now, you may or may not be familiar with e-signature, but it's through DocuSign or HelloSign. It actually allows people to sign things electronically. Now you can see that the fields of the agreement have been populated with what we typed on the screen, so it's fully integrated. And what that will have, the system will have sent, you can see here as the mediator that the claimant and the respondent have been sent through DocuSign a request to sign the agreement. If for some reason I'm unhappy, I can go back to void document and start again. There's one other special feature we built, which I would like to show you. We realized quite quickly that DocuSign and HelloSign, which are the ones we integrate with for e-signature, don't do what we do as lawyers, which is identify the signing clauses under which people will sign and adapt them. So we built some signing clauses and then we integrated them ourselves into DocuSign. So what you can do is identify who's going to sign and add another signatory if you want. So they may be a signatory who's not part of the mediation because maybe it's gone above their delegated authority of the people in the room. You can also then select other. So for example, you might say, actually, Laura Keily needs to sign this agreement. And what you can then do is actually decide how the other party is going to sign, and then you can specify how they're going to sign, and by which mechanism. So for us, that means you can select whether or not it happens under Section 127 of the Corporations Act, which is 2 directors or a director and secretary, given the privileges under the Act, or you can select whether or not it's going to be done by an authorised representative, and so on. And the agreement that comes up for signature will reflect those special clauses. So that's really all I wanted to show you there. I don't think I've missed anything, Nick, have I? Of import?
I think there's a couple of features that our judiciary members tend to really like. One is, which you can't do in real life, which is mute people who might be being maybe inappropriate or abusive or what have you, which is very important in domestic violence or family matters. And so you can see Laura's put muted by neutral. And so again, just gives the mediator or the member more power over the proceedings and the ability to control that. And, you know, we found that really important in family matters, which you might have referenced Paul before, where, you know, you might have someone who the location is unknown, the video's off, they're only on there by audio, and the ability to mute the other party. So it's trying to add some features to just make it a safe environment to be able to conduct particularly more sensitive matters.
You speak about the environment in which people are taking part in the proceedings. Nicole had a question. Can parties, i.e. not the neutral who has the subscription, engage with the platform via a smartphone or a tablet, or do all parties need a PC or a laptop?
Do you want me to take that, Laura?
Yes, please. Sorry, I just got an urgent message I'm trying to deal with.
So like anything, you know, at this stage, we're really encouraging people to use a PC or a laptop. And the reason being is, one, it's real estate, which I mentioned before about just the visual real estate. When you're in a real life environment, you know, you see people at the size that they are. If you're doing it on a screen that's this big and you've got a dispute with 6 different people, it makes it very difficult to pick up those visual cues. So there's a practical element to just how much you can see when you're using particularly a smartphone. If you've got a tablet, or, you know, me who's got a million devices around the place, then yeah, that's a little bit different. Yeah, you could use that. We are optimizing the software for mobile, particularly on the Dealmaker platform. So right now we're really encouraging people to utilize it on a PC or a laptop for that basis.
What about in terms of understanding the environment a person's operating? How do you ensure that there are no other people in the room who might be able to hear what's going on?
It's a great question. And this comes down to mediator management or neutral management skills. So I'll give you an example. I'm a predominantly a commercial or workplace mediator. I did a very sensitive mediation on the Immediation platform probably 2-3 weeks ago. And both parties were remote and rural communities in Australia. And it was a sensitive matter, and during the course of the mediation, I did a few things up front that was a little bit what I wouldn't normally do in a face-to-face mediation. The first was I confirmed that they weren't recording it because they didn't have consent. The second was I ensured that there was nobody else in the room, that we couldn't see, that they couldn't hear what was going on in the conversation, that it was a private proceeding, because I couldn't see other than what was on the screen. So that's what you do. You do a bit of upfront management with people. And if you were to break for a private session, you would again confirm confidentiality and when you came back. We had an instance in that mediation where somebody accidentally in one of the parties' rooms opened the door and walked into the wrong meeting room. And immediately there was a big reaction from one party. And so I just paused the mediation and said, folks, you know, it looks like someone's walked in. Can we just clarify what's happening here? And we had a conversation about that, confirmed that it wasn't intentional. It was someone who literally walked into the wrong room. We took a quick breather, put everybody into a private room. They had a break. We came back, we commenced again. So I think a lot of this, you do still need to have high quality human touch. It's not just about technology. It's just to augment the experience, which is particularly important in the world of COVID that we're living in now.
Thank you for that. It sounds like you've given us a pretty good basic run through of the many features that this platform currently has. And from the description and answer to the questions, it sounds like you've got more coming on virtually on a daily basis, which is really exciting stuff. We've got about another 5 minutes before some of our office assistants may need to go outside and play with their pink flamingo or become rather distracting. Can I just whip around the room of the participants and see if there are any other questions that people might have? So if you have a question for Laura or for Nick or for Mike, now is the time. Don't be shy. Now is the time to get those questions up. You can use the chat screen or put your hand up and we'll come to you. While that's happening, Mike, I think let's just pop back to you, shall we, and see if we have some feedback from you about what's been happening here today.
Well, I think what you can see, I mean, at Codr, we've done mediations online. They do work. It's a bit ad hoc, and what you can see is a hell of a lot of thought and effort has gone into this platform. That's why I personally would recommend it highly. I think it's very slick, and Nick is absolutely right. It requires experienced operators as well. So I wouldn't be shy in asking for help. Certainly in the early stages, we certainly provide that, and I'd recommend that in your first few goes at it is just getting some help as well.
So if people do want to have a bit of a play with the technology, what are the next steps for them? Laura, Nick, Mike, where should people go to find out?
At the moment, we're just allowing people to register on our website for the release of Dealmaker. If people have any urgent burning matters that they need managed in the next 5 days, and they would like to use our main platform, we can also assist with that. But we're trying to not get people familiar with one platform to only move them onto the other one in less than a week's time. So if you just contact us through our website, sorry, Nick, I know you're about to say something, or you can register your interest for Dealmaker and you'll be informed as soon as it goes live.
I just popped a URL into the chat function there. So you can pre-release, and as soon as we turn the button on, we'll give you access, and look forward to having you guys hopefully use the platform and really enjoy it.
There we are. So Dealmaker is the light version, if you like.
It is.
Of Immediation, and it's the one that really we've been talking about today. This is the one you can get on the monthly subscription. And
that's right.
I almost feel at this stage, Laura, like we should be offering a set of Ginsu knives with every purchase.
I feel that way as well. I feel a little bit embarrassed about it.
It's quite all right.
We are where we are.
I'm absolutely certain that at some point I'll be coming back to you and saying, what deal can you do for our AMINZ members and guests? And I'm sure there'll be one.
100% we will. 100%, no problem.
Absolutely. Look, thank you also very much for joining us this afternoon. Mike, thank you for taking the time, Mike Heron QC, in introducing us to Immediation. Laura and Nick, thank you very much for joining us. To all of you who've participated, thank you. And I very much hope that you've enjoyed it. We will be doing a lot more of these sorts of things. And if you have an idea for anything that you'd like to have us host, or if you'd like to volunteer to share what you're doing with the other members and guests on the AMINZ platform, then please don't hesitate. Just get in touch. You can reach me at executivedirector@aminz.gov. Nope, not quite. We're not there yet. At aminz.org.nz.
Not quite.
Not quite.
Not quite.
Give me a week.
You never know.
You never know. All right. Hey,
thank you so much for having us, everyone. It was really great to connect with you all, and hope to speak to you soon. If you ever need anything, feel free to pick up the phone and ring us. No problem at all.
Thank you very much.
Thanks, Sue.
Take care, everybody. Thanks, one and all.
Yes,
Bye-bye.
Bye.
Bye-bye.